Thank you, Las Corla. I move amendment number 1. And I, along with many other deputies in the House, wish to give my sincere sympathies to the former staff of Debenhams. It is a difficult experience for workers to lose their jobs. It is an experience that many workers across Ireland are having at this moment as a result of the global pandemic. And I do sincerely thank Deputy Barry for bringing this to the House today. It is timely and it affords the House the opportunity to discuss a very important issue, a matter we have committed to in the programme for government to enhance employee rights as creditors. Before going into the detail of what is proposed in the bill, I want to challenge the assertion that government has done nothing to help the workers of Debenhams. Instead, the government, as well as officials in relevant departments, have engaged with workers, with mandated trade union and with the ICTU. The Jobs Loss Response Protocol was put in place, ensuring that all available supports and information were and are provided to the former workers, including welfare entitlements, job search assistance and upskilling opportunities. This was reiterated during the summer following engagement I had with Deputy McAuliffe and a number of the former Debenhams workers at the time to ensure no one missed out on the available supports and information for workers. The government appointed Kevin Foley to independently review the Debenhams situation. And it's worth noting, Deputy Barry, that in his independent report published in December, he stated that the 2016 collective agreement had no legal application in 2020. The fact is, the state stepped in to provide redundancy payments, confirming that there was no money or asset there. And in recognition of the exceptional circumstances of this case, as reflected in the Kevin Foley report, the government was willing to allocate a fund of €3 million to be administered by Solace to support career guidance, training, education and pre-retirement planning for the former Debenhams workers. This was in addition to the €13 million of redundancy payments provided by the state. The Department of Further and Higher Education and Solace have been engaging with Mandate over recent weeks to provide clarification on the proposed design and operation of the support. Recently, the Labour Court provided mediation advice requesting trade unions consider making arrangements to allow their membership consider the clarified arrangements in a second ballot. I understand that the National Shop Stewards Group agreed that the €3 million fund be put to the ex-Debenhams members for a second ballot, and I welcome that. The government has done all that it can to ensure that the former Debenhams workers' legal rights and entitlements were vindicated, and indeed went further in this instance in recognising the significance of the situation, and this has been clearly outlined in the report by Kevin Foley published in December. What the government didn't do was unfairly build up former Debenhams workers' expectations of what could be done. And it is entirely regrettable that this happened at their expense and that some, I won't say all, but some exploited their situation for political gain. And it's heartening to hear Deputy Barry finally recognise on the floor today that no legislation could have retrospectively dealt with this situation. Turning to the bill now, Deputy Barry, I do appreciate your intentions in the bill and are in good faith. However, you can appreciate that putting forward proposals for additional preferential creditor status to a particular class of employee, in this case collective redundancy, raises considerable complexities. First, I wish to address the purpose of your bill, which in essence seeks to put one class of employee as preferred creditor above another in a redundancy situation. This has a knock-on impact on creating a secondary class of employee in redundancy. Preferential payments are provided for under Section 621 of the Companies Act 2014. A preferential creditor is one whose debts are deemed to be more important than the debts of another creditor. As the Deputy is likely aware, employees are already considered preferred creditors in terms of wages owed, outstanding holiday pay, sick pay, pension scheme contributions and statutory redundancy. Preferential debts also include rates and taxation claims, and so the state is also a preferential creditor. When a company is winding up, preferential debts rank equally. If there are insufficient funds with which to pay all preferential creditors, i.e. employees, claims are to abate in equal proportions, and in the situations of insufficient funds for statutory entitlements, the state steps in. The state steps in via the Social Insurance Fund, as is what happened in the Debenhams case. It is important to remember that current law is a result of careful balancing of the various rights of creditors, including employees. While preferential payments are facilitated under company law, the legislative basis and the policy underpinning them comes from other areas, such as employment and tax law. Section 621 refers to those relevant provisions in other legislation. Your bill proposes to amend Section 621 to provide that any redundancy payments and entitlements agreed under any contract of employment or agreement or custom or practice are included in the list of preferential payments in a winding up, and provide that payments due to those employees who have been made redundant as a result of employers' insolvency shall have priority to all other debts. As this bill concerns providing additional rights to employees, it is more a matter for the employment rights rather than company law. On that point, I would like to inform the House the Government is committed to further enhancing the protection of employees in a way that, unlike this bill, does not impede enterprise in their conduct of business, and I will elaborate on those proposals shortly. The bill proposes creating a special class of redundant worker in the event of the employer being insolvent, with legal rights that goes beyond those of a worker who was made redundant generally. To do so would represent the state picking and choosing certain workers over others as being more deserving of payments. This would neither be fair nor proportionate. Not all redundancies are a result of insolvency situations. Redundancies can occur for other reasons, such as employers restructuring or downsizing, but the business will continue to trade. Those employees would be at a distinct disadvantage if the company is not insolvent and would only be legally entitled to statutory redundancy. It is also important to remember that Ireland's system of industrial relations is based on a voluntary approach, and collective agreements are not binding in law. The effect of implementing this proposal would be to elevate the collective agreements on a statutory footing in an insolvency situation, with the state ultimately bearing the cost. It should also be noted that many creditors are SMEs and micro-enterprises who themselves are providing jobs. Were the workers to be moved ahead of other priority creditors and secured creditors, there would undoubtedly be a risk to the jobs of the staff engaged in other creditor companies. It must also be noted, in creating a special class of redundant worker, as provided for in this bill, there will be potential impact on state creditors, including Revenue Commissioner and the Department of Social Protection, recouping monies owed. That could be a major concern and would in turn further deplete the Exchequer and the Social Insurance Fund. I wish now to turn to the Government's commitment to further enhance the protection of employees in a way that does not unduly impede enterprises in the conduct of their business. To that end, both Minister English and I have jointly looked at legislative provisions that will deal with redundancy and insolvency from both an employment law and a company law perspective, and have had a number of engagements with the trade union representatives. We have set out a number of actions which combine legislative amendments in the areas of insolvency and redundancy law, as well as the provision of enhanced information in relation to those remedies designed to secure the protection of employees that are already a feature of existing legal landscape. In parallel, legislative proposals in the area of company law that are material to the protection of workers as creditors are also included. I will concede that progress is slower than I would have liked in this area, and I would like to see faster progress in the next number of months, and would say that while the amendment gives rise for 12 months, it's certainly not my intention that it would take that long. The Deputy referred to the general scheme for the small administrative rescue process, which will amend the Companies Act to provide a new dedicated rescue process for small and micro enterprise. And once enacted, will ensure mechanisms are put in place to protect jobs and prevent further redundancies as much as possible. The CLRG has made an initial report into the rights of employees as creditors, and we have used the opportunity of this bill to include amendments to progress recommendations made by the CLRG in relation to the provision of information to employees as creditors in a liquidation.
Thank you, Minister.
Just 2 minutes, a minute if I could bear your indulgence.
You'll get a chance to come back in, I think.
I won't be here. The amendments provide for a specific employee representative on the Committee of Inspection, which can be established to oversee liquidation. Phase 2 of the CLRG work programme, which is currently underway, looks at addressing the practice of trading entities splitting their operations between trading, and they will report in Q3.
Yeah,
and I just want to confirm that it is my full intention to honour the commitments made in the programme for government, and will do so over the coming months, and will not take the full 12 months.
Thank you.